All rise. The Court of Appeals Division 1 is now in session.
Good morning. Thank you for your courtesy. Please be seated. This is the time set for oral argument in our case entitled Glava versus J.P. Morgan Chase Bank, our cause number CV130719. As you probably know, we have reviewed the briefs, we've conferenced the case, we've talked about the issues, we're ready for your argument. Each side has 20 minutes. You don't have to use it if you don't have to. And we are already a few minutes late starting here. If appellant wants to take a few minutes, reserve a few minutes for rebuttal, let us know and we'll try to honor that. And then you have to watch the clock and say, I'm going to reserve the rest of my time when you get there. And if you would both state who you are when you begin speaking, that will help our recording. This is being audio and probably also video recorded. And with that, is it Mr. Meyer? Yes, sir. Please proceed.
Ronald Meyer, Your Honor, for the plaintiff. Your Honor, being that the court has read the briefs, I just want to emphasize a few things that I think are somewhat determinative in this case. The first is that we have a very narrow issue here. The court, Judge Oberbilling, very clearly said, I dismiss because under 33811C, all claims have been waived, period.
By not getting an injunction before the sale.
That's right. And discussion by appellee regarding whether the things were pled properly, whether there were facts to support it, are not of any consequence for us today. We're here on a motion to dismiss. And we all know that in a motion to dismiss that you take the allegations in the complaint as true.
As long as they're well pled.
As long as they're well pled. And you can maybe draw from public record, but that's not applicable here. And by the way, since Judge Oberbilling did not concern himself with being well pled, I don't know if that's even an issue before this court. Oberbilling did not say if they're well pled or not well pled, we'll dismiss. He said, period. I don't care how you pled it, they're dismissed. So we're coming before this court with the position that Chase Bank breached a contract, committed fraud, consumer fraud, wrongful forfeiture, violated 33420, breached their fiduciary duty, breached a covenant of good faith, and because of their chain of actions, intentionally inflicted mental distress on my client.
Is that all wrapped up in the sale?
No, none of it is. And I'm going to address that point.
Can you say that the wrongful forfeiture is not a part of the forfeiture, though?
Well, the wrongful forfeiture is probably one of the weaker arguments because, as the judge in the district court mentioned in the Grady case, that how can you have a wrongful forfeiture if there's no forfeiture? I don't want to spend any time on that. That's not the more important thrust of my case.
Help me out with the breach of the fiduciary duty issue. Is there a fiduciary duty owed between a lender and a borrower?
We've alleged it, and we've got to assume it's true. We're not here to debate. This is not a motion for summary judgment. There is a fiduciary duty. Well, now, as a matter of law, can you dismiss it? And by the way, Judge Oberbilling did not say, oh, by the way, there's no, based on what you pled, there is no a fiduciary duty. He said it's barred under 33811, period. So we're not here even to consider that.
Is the IIED claim well pled?
The
intentional infliction of emotional distress, is that a well pled claim under the complaint?
I believe it is, Your Honor. Okay. I believe it is. We're on a notice pleading state. It indicated the fact that there was a chain of conduct preceding this, and that this was a culmination of an intent to inflict mental distress. Yes, I think it's sufficient.
All right, thank you.
It's sufficient. In statutory construction, obviously you take the plain meaning of the statute. Understanding the 811 is in a statute that governs how you process and proceed with a trustee sale. doesn't discuss rights between trustee, trustor, and beneficiary. We waive defenses and objections to the sale. That's what the statute says. It doesn't say we waive everything. It says we waive our objection to the sale, and as I mentioned in the brief, it's obvious that it was well, forget that. Nothing's obvious. We rely on the BT case. And the BT case arises out of the facts of where BT had a trustee sale, thought it should have been given a deed. There was a second trustee sale. Another party purchased it. He comes into court now and wants to get the deed. He wants to invalidate the second sale. And the court said no. Now, there was language in there that says, quoting the statute, that tort claims and contract claims are waived, just quoted the statute, but it's in the context of an objection to the validity of the trustee sale. In other words, you can't use a tort claim to circumvent the statute that says that if you don't enjoin the sale, then you can't complain about the sale later. And also there's language in the BT case saying that there were tort claims that they weren't appealed. And so, very frankly, BT is somewhat silent on the issues that are before this court. But we have two other cases that help us. The Madison case said that because the plaintiff's cause of action depended upon the validity of the trustee sale, they're barred. That's key. Are the claims based on the validity of the trustee sale? In the second case, which was cited by the appellee in a footnote, and I'm sure the court already has it, but the Arizona citation is 233 Arizona 215, specifically said that claims under 33-420 are not waived. So we have one inkling here that the courts are saying that not all claims are waived because we've got one that's not going to be waived by the trustee sale.
That's the Sitton case?
Yes, sir. Yes, Your Honor. There's another case that is cited that is in a footnote that I want to address, the Grady case, which is a decision of the district court here in Arizona, where the court discussed the cause of action of wrongful forfeiture. It isn't much help because, first of all, it acknowledges we have the claim. Then it says there's some question of whether it's waived, but in any case, there wasn't wrongful because this went up on a motion for summary judgment. It wasn't wrongful because the defendant was in default. Then judge said, and by the way, I'll grant it. And by the way, the complaint asked for quiet title, so we know they were contesting the validity of the trustee sale because they wanted the property. And then judge granted them leave to amend. What meaning that has in resolving our case here, I don't think it's much, but I wanted to address it. Here's what I think is key. When does a cause of action result in objecting to the validity, not the validity, but objecting to, strike that. When does a matter rise to the level of waiving objections to the sale? And I think the Madison case is very clear. When the validity of your claim depends upon the sale, then you can probably say that claim arising out of that would be waived under this statute. Now, take the cases that Lava is alleging. I don't need the validity of the trustee sale to prove my breach of contract claim. Chase Bank entered into a contract to modify the loan. They refused to go forward with it. Now, granted, in the process, one of the pieces of evidence is going to be not only did they refuse to take payments and refuse to acknowledge it, they just demonstrated their breach by going ahead with a trustee sale, but I don't need the trustee sale to prove my breach of a contract claim.
In fact, counsel, the trustee's sale was noticed prior to entering into the contract, wasn't it?
That's true. I don't know if it was prior to or during. I don't know that, Your Honor.
Wasn't the trustee's sale initiated before September 2nd and I could be wrong on this, but I was under the impression that the trustee's sale was initiated prior to the early September execution of the contract.
I don't know if I would disagree with that, Your Honor. I know the trustee's sale was either during the negotiations and finalizing the contract. It may have been before. I don't know.
But the basis of the trustee's sale was clearly the non-compliance with the first lending agreement that was subsumed into the second lending agreement, correct?
The basis of the basis of the trustee sale was breach of the original promissory note. It was not breach of the modification of the contract.
Exactly. So if the basis of the trustee sale was breach of the initial promissory note,
yeah,
was not the original promissory note assumed or absorbed or something into the second note, and it was all made right? It was made new again, correct? They waived any claim to violations under the prior note.
Correct, Your Honor. Correct. The modification, in effect, said that we agreed to, signed by both parties, you're no longer in default, and we have changed the terms of the original note to not only make you in compliance, but to make it easier to make the payments and what have you.
Thank you.
The fraud and misrepresentation claim does not depend on the fact of whether or not we have a trustee sale. They represented they were going to modify. They represented they were going to not proceed with a trustee sale. They represented all those things that we alleged in our complaint, and it was false. I don't need the trustee sale to prove my fraud. I don't need a trustee sale to pursue a consumer fraud claim. Obviously don't need a trustee sale for violation of 33-420 because we know that's not waived. We've already got that established. So there's one claim that wasn't waived. The breach of fiduciary duty, did this whole chain of events rise to a fiduciary duty? And by the way, lender borrower transactions can rise to a level of a fiduciary duty. We've had all kinds of lender litigation. So that's a fact issue that's got to be resolved. Did all this course of conduct arise to a level of fiduciary duty? I don't need a trustee sale for that. Is breach of covenant in good faith and entering into a contract just thrown out the window because you have a trustee sale? That's not determinative. The intentional infliction of mental distress, how is that? I mean, it's one element of the proof as to how gross their conduct is, but I don't need a trustee sale. So our argument is that as a way to make an analysis in an area of which we have very little law on, besides the clear meaning of the statute, besides the fact it's in the context of a procedural statute on how to run a trustee sale, besides the fact there is nothing in that statute that indicates that every claim that touched the transaction in which a trustee sale was involved in gets waived, I think the examples I used in my reply brief, while maybe somewhat stretching, are very determinative. If you use the analogy of the appellee, you could notice a trustee sale. The trustor could come in and pay it off. And through either intent or negligence, they proceed with a trustee sale, and under their rationing, he'd be out. He couldn't sue for conversion because it arose out of a trustee sale matter. I mean, that's ridiculous. But that's the absurdity. The absurdity proves the position, in my opinion. And lastly, and I want to reserve time for rebuttal, I think I'll stop right there. There's no further questions.
Thank you very much. Mr. Erickson, is it?
Yes, sir. Good morning. May it please the court. My name is Doug Erickson. I represent J.P. Morgan Chase Bank with respect to this appeal. I'll try to make my comments brief because I think the briefs do, for the most part, adequately explore and discuss the issues. But I do think there are a couple of things that are particularly noteworthy, and one of them is the actual facts that this court must consider. They're the same facts that the trial court would have considered, but there are facts that precedent requires the court to accept as true with respect to this particular appeal. I don't think there's really any issue about the standards to be applied here. This court is going to review the trial court's judgment for an abuse of discretion. It's going to accept the well-pled facts as true. It's going to look at things like statutory interpretation, de novo. I would disagree with Mr. Meyer on one point, and this comes out in the brief, and I also heard it during his oral argument. This court can affirm the trial court's ruling if it is correct for any reason. And that's something I'll talk about a little bit as I go through my argument. It is true that an appellant cannot raise new issues on appeal to secure reversal of a trial court decision.
Generally not.
Generally not. But it is not true that an appellee can't point out that the trial court's decision is perfectly valid for some reason that the court did not apparently consider. And I think that's true because there's a judicial policy or philosophy that supports judicial economy, and realizing that if, in fact, the trial court's decision was right for the wrong reason, there's no reason to refer it back to the trial court.
I have a hunch you have some of the causes of action in mind on that point.
Well, I think all of the causes of action actually fall victim to that particular rule. But let me first just review with the court the facts that are accepted as true for purposes of the motion to dismiss. Some of them I think are pretty clear. Others may require just a little bit of work, and I need to explain to the court why they are accepted as true for purposes of the appeal. First of all, the plaintiffs took out a loan from Washington Mutual Bank. There's no dispute about that. Chase later acquired that loan. The loan, the repayment of the loan, was secured by a deed of trust. Plaintiffs defaulted. All of that is relatively clear. Plaintiffs applied for a loan modification 2 years after they defaulted. They were approved for a loan modification. While that loan modification was being considered and processed, contrary to the allegations in the complaint, Chase did not record a notice of trustee sale. That's what paragraph 7 of the amended complaint says, and that's what they argue, but that's one of those allegations the court does not accept as true, because what the recorded documents actually show, and in particular Exhibit C to our motion to dismiss, which is the notice of trustee sale, is that the notice of trustee sale, and there is only one, was recorded in, 2010.
The basis of the trustee's sale notice being the breach of the terms of the first promissory note.
That's correct, Your Honor.
Okay.
The loan modification that plaintiffs rely on for their case says in no uncertain terms, I further understand and agree that the lender will not be obligated or bound to make any modification of the loan documents if I fail to meet any one of the requirements under this agreement. The loan modification agreement also says in no uncertain terms that the payments begin on September 1st, 2012. Plaintiffs do not allege that they made that payment. In fact, what they...
Defendants allege that that constitutes a breach for purposes of bringing the trustee's sale. And wait. First off, under the new agreement, all of the prior sins were forgiven, were they not?
If, in fact, the loan modification became effective, if plaintiffs had performed, if they had met each of the requirements of that modification, I believe your conclusion would be correct.
Then where in the record do I find the notice of breach on the September through December payments?
Well, there is no notice of breach as to those payments because the breach was not, in fact, cured. It could have been cured.
Wait. You send a notice of breach out to say you're in breach, not to say thank you for having brought the payments current and no longer being in breach. Did you notify them of the breach for the non-payment of the September through December payments?
Well, as far as I can tell, Your Honor, the loan modification never became effective. As the agreement says,
Okay, hang on. If the loan modification never became effective, the loan amounts that were determined to be appropriate for January through March were based on what?
that's a question we never reach, and I do not know the answer to that question.
Once January through March was improperly assessed, that the sums were wrong, how were April, May, and June decided? The amount, when the bank figured out that January through March they were billing the wrong amounts, and this is clearly post-September through December, they're billing the wrong amounts, the payments were being made. Did anybody ever tell them, don't make the payments because you've already breached and we're foreclosing the note?
Well, as I recall the allegations that those kinds of statements were in fact made, were there...
And we've all been lawyers for too long. You don't make a casual comment about something like that. Did you ever notify them that they were in breach?
Because this was dismissed at the motion to dismiss stage, I do not know the answer to that question.
Okay, so January, February, and March. Now April, May, and June. They recalculate the number that was wrong in January, February, and March without saying we don't need to do that because you're in breach September through December, right?
That's the allegation.
Well, you've got the records. So they tried to pay January through March. Those payments were sent back because they were the wrong sum. They tried to pay April through May or June. They're going to get the recalculation done. Nothing happens, and then they get the notice that the trustee's sale from the prior note that had been absorbed into this new loan is now being brought forward. Is that correct? So the allegation of the violation of the first note is revived, even though it had been subsumed into the second note for purposes of trustee's sale in July, I believe, correct?
Well, I don't believe the original default was ever cured. What plaintiffs argue...
Okay, because your position is that the second agreement, coupon books or whatever aside, the second agreement never came into being.
Because of that provision that I quoted earlier, if they do not comply with every requirement, then the lender is not bound or obligated to make the modification. When they fail to make that first payment, I believe that is a violation of the requirements of the contract.
But doesn't the contract say that the execution of the agreement by both of the parties on or about the 1st of September constitutes execution of the note? I believe they signed it on the 2nd. I think you guys signed it on the 7th of September. It was supposed to be signed right in that general area somewhere, fully executed at that point, but you're saying it never came into being because 7 days before you even signed it, they hadn't made their payment?
They did not meet the requirements of the loan modification.
Go ahead.
So they don't allege that they attempted to make that September 1st payment, which was required. What they do allege is that they attempted to make payments in January. Another thing plaintiffs do not allege is that they did not know that the trustee sale was going to go forward. They allege only that no new or updated notice or status of a trustee sale was served on plaintiffs. That's in the amended complaint, paragraph 12. Now, I would simply point out to the court that that allegation ignores the fact that no notice of a continued trustee sale is required under the statutes. What the statute provides is that the person conducting the sale may postpone or continue the sale from time to time or change the place of the sale to any other location authorized pursuant to this chapter by giving notice of the new date, time, and place by public declaration at the time and place last appointed for the sale. That's ARS 33-810. What the plaintiffs also ignore is very clear Arizona law, which provides that once the original notice of trustee sale is given, the debtor is in a position to keep himself informed as to the status of the matter. And that's in the Kelly versus Nations Bank Mortgage Corporation case. There, the court rejected the idea that due process required any sort of shepherding of the litigants to continue to keep them informed as to postponements. And the Court of Appeals expressly held, we agree with the reasoning set forth by the courts in Stober and Nagel and adopt their conclusions here. The initial notice of trustee sale of the Kellys property complied with ARS 33808, and the Kellys do not argue that Nations Bank failed to comply with Section 33810 when it postponed the sale. Thus, it became the Kellys' burden to stay apprised of the new sale dates. So, and I mention this because I think it's important with respect to the notice issue, because I think Madison versus Groseth resolves this case, but there is some discussion in Madison about notice, and I want to get to that in just a minute. But I think it's important to know that the plaintiffs don't actually deny that they had knowledge that the trustee sale was out there in the works. And what the Arizona precedent and the statutes clearly do is put the burden on them to remain informed as to the developments with respect to that trustee sale. We also know...
Counsel, correct me if I'm wrong.
Yes, sir.
And I may be. But isn't it their position that they were assured by the bank in the January, February, March year that the trustee's sale had either been dismissed or they would not be going forward with it?
What they allege is that prior to signing the loan modification agreement, a representation was made that if they modified their loan, there would be no trustee sale.
Okay. And your position, again, is that they didn't execute properly, they didn't make their payments, so none of that matters.
They didn't meet the very first requirement of that loan
Well,
modification.
let's go into the home modification agreement. What are you saying they didn't do?
I'm saying that they did not make that very first payment, which was...
Yes, but what provision under sections 1 and 2 of the HAMP agreement are you saying they violated? Because as I understand it, 1 and 2 are, the idea here is that the two parties will sign the agreement, and as long as all the subsections of 1 and 2 are met, that the agreement will be effective as of September, as of the signing, or as of September date. So which provisions of 1 and 2 are you saying, based on the record, based on the complaint, the amended complaint, weren't met?
That's one way to read the agreement. And what I'm talking about is the payment in Section 3. But I would also refer you to the last part of Section 2, which is the language that I quoted earlier, which does not limit the requirements to those under 1 and 2, and it simply says, I further understand and agree that the lender will not be obligated or bound to make any modification of the loan documents if I fail to meet any one of the requirements under this agreement, not sections 1 or 2.
So you're basically saying that it's a nudum pactum, that we're going to enter into this agreement, but if you fail to abide by any of the provisions of this agreement, I'm not going to, the modification is over. There is no modification. Isn't that what you're arguing? That's the way you're reading this?
It's not quite that broad. And I think, in fact, had they made the first payment and not made the second payment, for example, I don't know that we would have that same question. Because there comes a point where the provisions that we're talking about, I believe, are conflicting. And, of course, it's an issue that the trial court didn't address. We didn't brief below. And so I don't know what the full resolution is. But the way I read that last part of Section 2, given that it was the very first payment, the modification is going to become effective on September 1st, except they don't perform. They don't do what's required on September 1st.
They're pretty contradictory comments, because it's provisions. I mean, because one, in essence, paragraph B, 2B, says that I understand the loan documents will not be modified until everybody signs them and returns a copy, and the modification agreement, as defined in Section 3, has occurred. And that's the September 1st date. And then paragraph 1 of that provision says, if prior to the September 1st date, then any of my representations are no longer true, in Section 1 are no longer true, or have not been performed, then the loan documents will not be modified and this agreement will terminate. The last section seems to really expand on that and say, regardless of whether all the provisions of Section 1 have been met, regardless of whether all the provisions of Section 2A have been met, regardless of whether everybody has signed all of these agreements and September 1st comes and goes, if you breach any provision of this agreement, we will not be obligated to make any modification. I mean, it seems to me that sentence is almost nonsensical, because you've already made the unless it's a nudum pactum, because you've already made the modification. Everybody signed off on it. Everybody agrees that all the other terms have been met. And then if they fail to make a payment on it, you say, well, this modification is then void.
Retroactively.
Retroactively. It never existed.
Never was.
It never existed.
I agree with you that there is conflicting language in the agreement, how that would have been resolved, and I'll explain to you why it's not going to matter in a moment. But I do think my argument would be different if, as I say, if they had made that first payment and it was somewhere down the road. I don't think it would be a reasonable interpretation or in a projection of the party's intent.
They did make a first payment down the road. They made it in January. And they made it based on coupons that were provided to them by the bank. They were the sums on the coupons that they paid. When did those coupons issue?
That I don't know.
After September 1st?
I do not know. I apologize.
My only point is, if it's 5 months later and there's no notice of default on the modified agreement, it would seem that the bank was proceeding apace and acting as if they had a right to rely on the bank's integrity, that the loan is in place and we're honoring its terms, wouldn't it?
Due to the procedural posture of the case, quite candidly, this is not a case where I have reviewed the loan file, the foreclosure file, all that. So I'm not in a position to answer your question.
Right.
It does seem to me that the sentence we were debating a couple of minutes ago, could be read as just simply a little bit of extra boilerplate to say, if I, the lender, the borrower, don't meet any of the requirements under this agreement, meaning the preconditions to the modification, then the lender isn't obligated to make any modification. It seems to me it's sort of more like this, it may be a little bit duplicative, but it's better than having it be sort of being circular, where it's basically saying, yes, we have a modification, but if you're violating the provision of the modification, we don't have a modification, which is sort of circular. It would most be better to interpret that section, it seems to me, or more reasonable to interpret that section as meaning, so in essence, if you don't mean any, if sections 1 and 2A and B are not complied with, you understand that we don't have to go forward. Yeah.
I don't disagree with you that would be at least one side of the argument. Yeah. There would be another side of that argument as well. So I only have about a minute and a half left, so let me sort of jump ahead. I wanted to go through each of the claims and explain to the court why the claims were not adequately pled. So the plaintiffs failed to state a claim from the beginning with respect to each of the counts. Some of the court's questions during the first remarks, I think, cued in on some of those points. For example, with respect to the breach of fiduciary duty, there are no adequate allegations to establish a duty, and it runs contrary to Arizona precedent. The fraud claims, be they consumer fraud or common law fraud, are not pled with particularity. And for that reason, although the court never reached that issue, that is another basis for affirming the court's decision. And let me just skip to my final point because I think it's important. I think this court is going to focus on the Madison versus Grothseth case.
I know you're running out of time, but why do you think the breach of contract and the breach of the covenant and good faith and fair dealing claims weren't adequately pled?
Well, that goes back to our discussion simply of the effectiveness of the loan modification. Okay. So I think in deciding this case, the court is going to focus on the Madison case. And under Grothseth, Madison, the plaintiffs are not able to challenge the validity of the trustee's sale. I think we're in agreement on that point. And so the question becomes, if you can't challenge the validity of the trustee's sale, And by the way, I think all of these claims constitute an objection or a defense to the trustee sale itself. So by the very clear language of the statute, they're waived. But the way to ask this question, I think, is if the plaintiffs cannot challenge the trustee sale at this point, and I think that's what the statute says, I think that's what Madison says, I think they agree with that. So for purposes of their claims, that trustee sale is presumed to be valid. If that is the context in which we're looking at those claims, do any of their specific claims, any of the 6 of them, survive if they can't challenge that sale? And I think the answer is no.
Thank you.
Thank you very much. Mr. Meyer, you have a few minutes for rebuttal.
I've got 6 minutes and 36 seconds.
I think that's correct.
Don't feel obligated to use all of them, though.
True, Your Honor. Let me address this business that you can, if you can affirm it under any basis, you affirm it, the lower court's decision. Here's the problem with that in this case. If Judge Oberbilling just says, grant motion to dismiss, hey, may have some validity. He didn't. He said, I grant it solely because 811C says they're precluded.
Mr. Meyer, do you have a case that supports the view that we cannot affirm the trial judge on any basis supported by the record that was an argument that was made below if the trial court says, I'm only granting the motion on this basis?
Other than the general line of cases that says that you can only appeal from the specific conduct of the trial judge, that's what I'm relying on.
Okay.
And by the way, I have to apologize to the court. In my reply brief, I misquoted 811 and said 809, and I don't know if anyone picked that up. If you didn't, then I don't worry about it that I overlooked it. So the general broad brush, well, I find something to affirm it on and we can go home, I don't think applies here. I don't think it applies. Judge Oberbilling was very specific. And he narrowed it, I think, for a purpose that will give us an opportunity to clarify an issue that is very prominent in this, in our business world. The other thing is that I want to bring to the court's attention is the very scenario that went on between counsel and the court. We're arguing facts again. You can't argue facts in a motion to dismiss. He says, well, they didn't make a payment until they didn't make the December payment. Well, there's a problem with that. If this was a motion for summary judgment, we'd have an affidavit in effect says, and I'll tell you what it would say. It would say, I asked for a payment and they didn't get me the cards to January, and then I paid them. It's a little incredible.
Counsel, in fairness, paragraph 8 of the amended complaint says that the HAMP agreement basically says the payments are due starting in September. And the paragraph 8 of the amended complaint on page 3 says the plaintiffs remitted checks in the months of January, February, and March.
Yeah. And the testimony would be, Your Honor, is that we tried to get the payment cards and they didn't give them to us. They finally got it to us, and as soon as we did, we paid them, and they accepted them, and they didn't send it back.
You allege, well, you allege that the plaintiffs requested the payments be made in 2 amounts. Chase approved, as long as the total payment was received for the due date, and you said they were January, February, and March were paid before the due date. And you said essentially the same thing about April, May, and June.
Yeah. Well, and my comment is that to hang on the fact you didn't make a December payment, it somehow nullifies the whole agreement. First of all, it relies on facts that are not before this court, and rightly so, because this is a motion to dismiss, not a motion for summary judgment. And their own conduct is somewhat contradictory, that if this was such a big deal, you're now accepting and rejecting 6 months of payments, not because you didn't make it in September, but because we didn't give you the right amount. Enough said. My point is, when you start arguing facts on a motion to dismiss, you lose, because we're at the disadvantage that we don't have a developed record. Counsel can say, well, you didn't make the December payment. I come back and say, well, look at you told us we don't have the right amount. Where does that leave the court? That's why we have the rule. Motions to dismiss take the allegations face value, and we don't argue facts. One last comment on this business about Glava was supposed to keep informed about his trustee sale, and the court very aptly brought it out. What happens if the beneficiary fraudulently misrepresents that we're going to take care of it and don't worry? Does he have to doubt the person who just signed a modification agreement saying that we're going to take care of it, and now check the record every week to see whether or not they're going forward? I mean, that's ludicrous. It's ludicrous. Lastly, Your Honor, and counsel did not address it, but you've got to. If you maintain counsel's position, Chase Bank could intentionally take the trustor's money, purposely not cancel the sale, and he's out. Total. What is the answer does Chase Bank have to that? Is that their position? We can do that under the law. Chase Bank can represent that it'll compromise and cure a default and then continue with it. This case, they obviously say we can do that. Chase Bank can accept the trustor's money, and because it's many times at big banks, the left hand doesn't know what the right hand is doing. Someone negligently fails to cancel the trustee sale, trustor is out. They can do it. That just isn't the law in this state. You cannot misconstrue 811 to permit Chase Bank or anyone else to perform that conduct. Thank you. I didn't use all my time.
That's all right. Thank you very much.
Let's get back on schedule.
Yeah, we'll take the matter under advisement, issue a decision in due course. We thank you both for your arguments and for being here today. Thank you.